Just get up here and get it started. Get up, stand back, I know, I just offered the 10 now. Oh. Background music?
Next year we're going to have moving dinosaurs.
Next year I'm looking for chairs.
Good. Good afternoon, everyone. If we could start to sit down, we're going to try and get started. We're running a little bit behind, so we want everyone to be able to get to the cocktail parties. All right, we're going to go ahead and get started. Welcome, everyone. Thank you for joining us at the 2024 edition of CourtWatch. As you know, this has been a staple of the Business Summit for more than 30 years, and we're excited to continue the tradition. It's been a very exciting year with the court, and we're going to take a look at how the ICA has affected cases up at the Supreme Court and much more. So we're running a bit behind. We're going to try and get through by 5. So without further delay, please join me in welcoming this year's CourtWatch presenters, Mark Williams, Susan Denneker, Jay Ford, and Tom Herney. We also would like to give a huge thanks to this year's sponsor of CourtWatch, Progressive. And also extend deep appreciation to everyone who contributed to our written CourtWatch publication, which if you didn't grab one on your way in, we have them at the back of the room. If you scan the QR code, you'll have access to our written PDF that has summaries of all of these court cases and more. And with that, Mark, you can get us started with the stats from the past year.
Thanks, Caitlin. Go to the first slide. If you've been to CourtWatch before, you know that we usually track the number of decisions historically from the Supreme Court of Appeals, both memorandum opinions and signed opinions. You'll notice that we do this by court term, and there's variation because the fall term is significantly shorter than the spring term. So there are fewer cases produced in the fall term than the spring term. The big question that has come up with the advent of the ICA, and we'll look at the ICA here in a minute, is how that has impacted the decisions. What this shows us is not much. Not much in terms of the productivity of the Supreme Court of Appeals. They still do about the same number of appeals. They're, as usual, heavily reflected in the memorandum opinions, which are the unsigned opinions that handle issues of established law. This past spring's term had a few less signed opinions than in the past. If you look at spring of 22 and compare that with spring of 24, it's about a 30% reduction. That could be related to the ICA, so let's look at their cases now. As you can tell, from fall 22 forward, they were getting ramped up once the legislature approved them and they started actually hearing cases. They now have a pretty full docket. And while most of their cases at the outset were relating to workers' compensation and family court, they're now doing a lot of the cases that we tend to focus on, which are the civil cases involving products cases and consumer finance and that sort of thing. And in fact, we're going to talk about several ICA decisions today. What we don't know, and we probably will have a better idea for next year, is the extent to which cases are being decided by the ICA and then appealed to the Supreme Court of Appeals. The way the court rules work now, there is an automatic review of cases that are appealed from the ICA to the Supreme Court of Appeals, although my guess is that not all of them are going to get full consideration. They may result in memorandum opinions and that sort of thing. But the bottom line is, in analyzing the statistics, the ICA has done what it was intended to do, which was give us more opportunities to have some undecided issues of law addressed, and it has not adversely impacted the Supreme Court's docket.
Good afternoon, everyone. I'm Susan Denneker. It's nice to be with you all again. Before I get started into my slide, I want to give a shout out to Anna Daly. Anna was our fearless leader for a long time. I got to join the team a couple years ago, but we're so excited to have Anna here. We told Anna that we didn't give her the clicker this year, but she does have the right to throw us off the stage if we get too close to the cocktail hour. So just want you all to know we're in good hands here with Anna. You guys that follow this every year may remember that when I started on this esteemed panel, I got assigned the tax cases, which I do think was a form of hazing. I've moved up to judicial hellholes. So I feel like I'm going in the right direction. Actually, good news here. West Virginia, there's an annual report which gets put out by this nonprofit that looks at cases and judicial trends in different states and looks at how business friendly, candidly, they are. West Virginia historically has not fared well on that report and has been classified as a judicial hellhole, which is, something no state really wants to be on a list like that. But we're on a points of light list this year. We have been moving up and have not been to be deemed a judicial hellhole now for a couple of years, and now we actually are a point of light. Two things that are cited in the most recent report that led to that. One is the Speedway case that we talked to you about last year. For those of you that follow some of these cases, it's an interesting case. New hire at Speedway, still watching orientation videos, comes in, she's tired. The supervisor says, do you need to go home? You're yawning, you're nodding off during the orientation videos. And we all know how exciting those videos are, right? I mean, they're really stimulating. She said, I'm tired, I've got stuff going on at home, a little preoccupied, I'm fine. They ask her to work an extra hour. She agrees. They actually offered to let her go home. So she works 9 hours instead of 8. She leaves there. She goes to her son's school. She runs some errands. And then she's involved in an accident where, unfortunately, she kills another driver. She tests positive for all kinds of drugs. And there was an allegation here that Speedway should have known that she was under the influence. And, in fact, she admitted that she took prescription drugs she wasn't supposed to take. Before she came to work, she said she took them in the bathroom. But there was no evidence that Speedway knew anything about it, supplied her with anything, or had any reason to know that she was under the influence. Big decision here from our state Supreme Court in 2023, just a year ago, where they said, that's not enough to put the employer on a duty here, right? Sometimes where we've seen that is when an employer provides the alcohol, right, or the drugs, or knows somebody's under the influence and sends them home. Those are things that are affirmative acts that can create a duty. Here, Speedway didn't do anything wrong. It was a big deal. It was a $2 million verdict against Speedway. A jury had found it 30% responsible for the accident. And so setting that aside was a big deal. The other thing that got highlighted in this report was a change that our legislature made in 2023 to the deliberate intent statute. For those of you that have workforces and have business, you know that there's immunity for workplace injuries for your employees if they're injured on the job because you are required to provide workers' comp insurance. There's an exception, though, if an employee can meet the test to show that the employer acted with deliberate intent to cause the injury or to cause a condition that caused the injury. In 2023, the legislature capped the non-economic damages, pain and suffering, emotional distress damages, and because of that cap, that was another reason that we're on the point of light list for the judicial ho-hos. So good news for business. That's something that gets some publicity and some traction, and we're a point of light. So we'll take that.
Let me talk about a couple of products liability cases, one in the Supreme Court, Shears versus Ethicon, and one that is decided by the ICA, Ford Motor versus Tyler. These are both significant decisions, and you've got to go back a number of years to get a substantive products liability decision in West Virginia. This area law tends to grow in fits and starts, and I think you go back to 2018 where the court decided that a name brand manufacturer couldn't be held liable for injuries caused when somebody took a generic drug. And back there, I think you go back to 2007 or so, the Carl case where the court found that we don't follow the learned intermediary doctrine, which is if the pharmaceutical company warns the doctor, then they can't be liable for lack of warning to the patient. And as you know, the legislature subsequently fixed it. So Shears versus Ethicon is a significant case. And Shears came out of the transvaginal mesh litigation. It was a product that was used if you have incontinence and used by a lot of doctors. And a lot of litigation gets into multi-district litigation and ends up in the Northern District of West Virginia. Ends up going to trial in Kanawha County. I got my cases mixed up. So in any event, the Shears was tried in federal court and went to the Fourth Circuit and came over on a certified question. So I'll get this straight. Anyway, so when you sue over products liability, one of the things you can sue for is a design defect. And the question is, you say the design is faulty for whatever reason. In Shears, they said the design of this medical product was faulty. But there's a real question about what you have to prove as, is there a better alternative design? And so when Shears came up, they concluded that you had to have an alternative design that eliminated the risk. So think of it as the elimination rule. And in part, the district court found that the elimination rule applied because that was what was in West Virginia standard jury instructions. And so ultimately, the plaintiff's expert is excluded, they go to trial, and there's a defense verdict. The Fourth Circuit gets it and says, wait a minute, we don't know what West Virginia law is. So they certify the question over to the West Virginia Supreme Court. And the court held, no, we're not going to follow the elimination rule. But you have to show that there's a feasible design that would have substantially reduced the risk of injury to the plaintiff. So that's the syllabus point. The other syllabus point deals with the jury instructions. And just to briefly summarize that, the court just found that the jury instruction wasn't a correct statement of West Virginia law to the extent it suggested it was the elimination rule. So the way this works goes back over to the Fourth Circuit. The Fourth Circuit entered probably about 30 days ago an opinion where they found that the district court had improperly excluded one of plaintiff's main experts because they applied the wrong rule. So you think it gets tried, it goes up, it goes over, it goes back down. So it's pending probably trial in the district court. So then one of the things they said in Shears is we are vacating the ICA's opinion in Ford versus Tyler. So Ford versus Tyler was, it was a car wreck, and they alleged a crashworthiness issue on design, which is you didn't design the car to be able to withstand a crash. But there's also an oil pan issue. They said that was badly designed, and what happened is the guy's in a wreck, he's stuck in a car, and it catches fire. And it was the defect in the oil pan that caused the fire. And so similar thing, they go to trial. There's a verdict against Ford. They take it up. And the ICA, and again, this is before Shears. Maybe I should have done this case first once I got lined up on what Shears was exactly about. So they go up, and this is before Shears, and they decide we're going to follow the restatement third. And they reverse the verdict for the plaintiffs. So you have a 3-0 by Judge Scarr, and then Shears comes along, so that's vacated. So that's because that's not the rule. The rule is substantially reduce the risk of injury. Shears is still, it's fully briefed, pending in the Supreme Court. I have tried to figure out what they're going to talk about, and I'm not entirely sure. But they're going to proceed. So that case, my guess is the Supreme Court is going to do the same thing. They're going to remand it back down, and both cases will end up back in front of trial courts to apply the appropriate rule. But really significant change in West Virginia law, and worth for all of you who want to get up tomorrow morning and read cases. These are two that are worth reading.
All right, next we have 3 negligence cases. And as many of you know, West Virginia courts have historically been pretty reluctant to grant summary judgment in negligence cases, instead opting to send the issues to the jury. More recently, however, there seems to be a trend for courts both at the circuit court level and at the Supremes to grant summary judgment to the defendants as a matter of law on certain negligence issues. And we have 3 we want to highlight for you here today. So this first one, Boyce, in this case it involved a delivery driver who was delivering construction materials to a customer's home, and when he got to the customer's driveway, he saw that there was low-hanging communication lines that prevented his truck from driving into the driveway. So he gets out of his truck, climbs on top of it, and pulls out some saran wrap that he has apparently just for this occasion, and wraps the communication lines to try to bring the clearance up a little bit so he can drive through. Unfortunately, as he's doing that, as he's wrapping the lines, he touches a live power line and is electrocuted and suffers significant injuries. So they brought a negligence case. Circuit Court granted summary judgment in favor of the defendants, and the plaintiffs took it up to the Supreme Court. And the Supreme Court held that the defendants could not have reasonably foreseen that someone without any electrical training would climb onto a truck, shrink wrap the wires, and inadvertently touch a power line. And the court further held that in addition to that it was the plaintiff's own willful and intentional actions of wrapping the lines that caused the injury. So there was no liability there. Next is the Orzo v. City of Logan case. And here the plaintiff allegedly fell when she had tripped on a cable loop that was wrapped around a pole that was on church property and is extended onto the city's sidewalk. Now in discovery, it was revealed that this cable had been there for 10-plus years, that neither the city nor the church had ever received any sort of complaints or notice that this was causing a hazard. And in fact, the plaintiff in question had walked past it on a regular basis for the last year or so, including a couple of times before on the day of the injury. The court again said no liability. The plaintiffs don't have any evidence that the city knew or should have known that this cable caused a hazard. And last, we have the Hayes v. Kanawha County Kanawha Valley Regional Transportation Authority. In this case, the plaintiff got on a bus, rode it to her desired location, and then got off the bus. And as the bus was pulling away, she went to cross the street. And unfortunately, she was struck by an oncoming car. And in this case, the court recognized that the Transportation Authority, as a common carrier, owes the highest duty of care to passengers who are getting on, riding on, or getting off their vehicles. But after the passenger gets off the vehicle, that person becomes a pedestrian to whom the Transportation Authority owes only a normal duty of care, like any other pedestrian. Here, the court said it's undisputed that the plaintiff got safely and freely off the bus herself, and at that point, she became a pedestrian and got to choose when and how and where she would decide to cross the road. So again, no liability. So the upshot of these cases seems to be that, kind of unlike the days of old where a plaintiff could be sure that they would withstand summary judgment by generally just alleging some vague issues of negligence, the courts here seem to, both at the circuit court level and the Supreme Court level, seem to having a more kind of probing analysis to say, hey, do you show us evidence that that you can actually meet the elements here? So that's a trend that the business community certainly likes to see and has been working on for a long time.
All right, let's talk about some COVID cases. In 2021, the legislature passed the COVID-19 Immunity Act, which provides immunity in lawsuits arising from COVID. There's one exception that they wrote into the statute, and as it turns out, for these two cases, they dealt with the same exception. The important thing about these kinds of cases is to find out whether courts are giving reasonable deference to the legislature when they make a decision regarding an issue like immunity. I mean, at common law, and we have a constitutional provision that says there has to be a right for a remedy, and courts are open for those reasons to provide redress for it. But we know with a lot of circumstances, physicians, skiing operations, et cetera, that there are immunity provisions, law enforcement officers, there are immunity provisions that the legislature has built into a statute. These are the first two cases that have had an opportunity to address that. And in both, Bond actually was more of a labor and employment type case, but elder care was relating to care at a nursing home. In both of these cases, the courts, and one's an ICA and one's the Supreme Court of Appeals, in both of these cases, the courts recognized that the legislature had the right to provide immunity, but that if the plaintiff's lawyer drafts a complaint that arguably could fit within the parameters of the exclusion, that it is improper to dismiss it on that basis. So I think that to the extent that we're going to see any more COVID-19 litigation, and that would be because of somebody got COVID at work or somebody's coworker had COVID and transmitted it to someone else, as an example, or an employer didn't have sufficient COVID-19 protocols in place. All those things are subject to immunity for state-based claims, except for the exclusion, which says that if there was evidence of intent and malice, those circumstances might allow a case to go forward.
Well, employment cases are always fun because nobody does more crazy things than employees, right? And so we love these facts all of the time. We'll start with the Gerald versus Frontier case. Gerald was a cable service technician and he worked for Frontier. Frontier fired him because they said you took your bucket truck home to get rid of your bat infestation without permission. Gerald says, no, you actually fired me because a year ago I came forward and told you that some of my colleagues were intentionally sabotaging cables so that they could get overtime. Who thinks like that, right? So I don't know if that was true or not, but he had made that allegation. In the meantime, Gerald had some other issues, maybe a positive drug test that was grieved and not showing up for work on time. But there is a statute, there's a criminal statute in West Virginia which criminalizes interfering with communications cables. Who knew? But it makes sense. And Gerald says, not only did I report this, but you wrongfully discharged me because I reported something that relates to a public policy of the state of West Virginia. So some of you that are familiar with employment law will know that we all the time talk about employees being at-will employees. I see my colleague Larry Rector in the audience. I remember one time talking to Larry about a situation for a client, and I started with, the employee is at will. And he said, you better have something better than that, Denneker. Right? So we talk about being at will, that you can be let go for any reason, but it can't be an illegal reason, right? And if it violates a public policy of the state of West Virginia, then you can have what's called a harmless claim or a wrongful discharge claim in West Virginia, which can be actionable. And that's what Gerald says here. I complained about something that was illegal. My colleagues were engaging in sabotage. There's a whole criminal statute on this. This is a public policy of the state of West Virginia. Our state Supreme Court says this criminal statute actually doesn't establish a substantial public policy of the state of West Virginia, which is sufficient for a harmless claim, which is pretty interesting. At times we've seen the court kind of go in and out on what's a substantial public policy claim. You may remember that years ago the court found that cosmetology regulations were a substantial public policy here. In this case, the court says no. This is a criminal statute that really is a property issue. The statute itself, one, doesn't say it's a substantial public policy or say that it really represents the public policy of the state of West Virginia, although maybe arguably every statute is a public policy of the state of West Virginia. But more importantly, there was no public issue here. There was no issue that impacted the public. This really was a property issue. To the extent that the co-workers were sabotaging Frontier's cable, that was a Frontier issue. It didn't impact the public. Gerald made an interesting argument. He claimed that there were at least 2 people whose communications cables were out and could not make phone calls due to his co-workers' sabotage, who needed emergency assistance, and he claims that 1 person died. The court said, no, not enough, no claim here, no cause of action. So, pretty good employment case for employers. Let's talk a little bit about the Shepherd University case. This involved 2 campus police officers who were terminated essentially because Shepherd found that some of their actions were inappropriate as it related to some of their policing duties and how they interacted with students. There was a concern about misrepresentation on a report and whether there was lawful entry into a student dorm room where students may or may not have been drinking. I'll leave that up to you. But to believe whether that was believable. And also there was a traffic stop involving student athletes, which I think was a proper stop, but there was a concern about how the officers handled the stop. The officers get fired, and they bring every kind of claim: age, disability, whistleblower claims, and again, a wrongful discharge claim. There was evidence here in this case that these officers had made a multitude of complaints about various things. One of them had made an ethics complaint that another officer was using a state vehicle for personal use. One of them had grieved a failure that he had not been hired in alleged age discrimination, and a grievance that he ultimately won. Both of them had raised complaints that the university allegedly had kind of some agreement with the magistrate court that if students were arrested, they would just kind of get community service without going through a formal process. Do you hear what I'm saying? There was a lot of smoke, right? There were a lot of things here. And as a result of that, the circuit court had said, those complaints were about a year old, most of them. There's no temporal proximity between when those complaints were made and when the discharge decision was made. The Supreme Court said, there's a lot going on here, right? And we think a jury gets to decide whether or not you believe the reason that the employer gave, whether it really was for these police issues and how these officers handled it, or whether some of these other complaints were a factor in it. So this is not unusual. A lot of times when we see a lot of factual issues and a lot of complaints, that can be a red flag about whether the jury's going to get to decide that. My favorite fact of this case, one of the officers brought a disability discrimination case. He claimed that he had diabetes, which caused him to have to urinate frequently, and that he believed that that was a part of the reason for his discharge. The court said there was really no indication that that had ever come up with the employer. They did get summary judgment on that claim. The Supreme Court upheld it. The only time it had come up was when the officer had left his body cam on when he used the restroom, and the university said, don't do that. Court found that that was reasonable. I agree with that. And of course, we can't talk about employment without talking about drugs, right? We always talk about drugs when we talk about this. And this is an interesting case. Daniels was a customer service rep who worked at Yeager Airport, right? She checks you in, she gets your boarding pass, she asks you if you have any e-cigarettes or batteries in your luggage, right? She makes sure you're not overweight, and that you're not doing anything terrible as you get on a plane. She goes off on a medical leave. Her employer had a policy, a very clear policy, that if you were gone for more than 30 days, you can't return to your position without a drug test. So she comes back after that time period, and her supervisor says, go get your drug test before you come back to work. She shows up at the testing facility, and then she texts her supervisor and says, Actually, could I wait to do this until later? Has anybody ever had that from an employee? Usually there's a reason why somebody wants to wait. There was a reason, and she admitted to having ingested marijuana gummies a few weeks earlier. Now, Daniels worked in West Virginia, but lived in Ohio, and she had an Ohio medical marijuana card. She had never raised it with her employer. The employer prohibited the use of any drugs. In fact, fast forward, guess what? She does test positive for marijuana. She tries to protest it. She is let go. She challenges this. And she says, look, employers should have reasonably accommodated me. I have some physical disabilities. It does look like she did have disabilities. And you should accommodate me by allowing me to use the medical marijuana that I have a prescription for in Ohio. Court said, no. Marijuana is illegal in West Virginia unless you have a West Virginia medical marijuana card. She did not have one. Employer does not have to accommodate you by allowing you to have illegal drug use. She also said, well, you retaliated against me because I asked for more time and you wouldn't give it to me. That argument was, I thought, a little bit difficult on her side. The court said, no, you got let go because, right, you tested positive for marijuana. And then she says, you know what? I've got a claim under the West Virginia Medical Cannabis Act because I should be allowed to use this. And the court also said, you know what? You actually don't have a claim because you're not, one, they didn't reach whether there was a private cause of action under the statute, but they say there's no way it could apply to you. You're not a resident of West Virginia and you don't have a West Virginia card. Now, as you guys know, that statute would also prevent, you don't have to allow marijuana use under the statute, in even medical marijuana, on your premises. So they didn't have to reach that here because we have an Ohio issue. And then the last thing the employee said was, this is a violation of my privacy. You should not have even drug tested me. And we go back to the old drug testing tests here, and we look at whether she was in a safety-sensitive position. The court found here that the customer service agent who's making sure that we've got safety on our aircraft, that was a safety-sensitive position. Interestingly, there was some FAA review of her position, which didn't find that for FAA purposes that it was safety-sensitive. Court says it doesn't matter here. For purposes of our state law, as it relates to drug use here, it is safety-sensitive. I do want to give a shout out, though, for what I think an important takeaway of this is, and that is the employer had really clear policies about when it was going to require drug testing, that it prohibited the use of drugs, and what was going to happen if you tested positive for drugs. That was important in this case. And the other thing that I want to remind everybody of is that West Virginia passed a pretty comprehensive drug testing statute several years ago, the West Virginia Safer Workplaces Act. If you have a policy that complies with the Act, and it's got some very specific provisions, you generally have a lot of leeway in terms of being able to test employees. And so as you go back and you talk to your HR people and maybe your legal team, look at those policies because you want to make sure, one, you have a good policy in place, and two, you want to make sure it's compliant with the Safer Workplaces Act.
SWN production and City of Weirton, it really deals with the kind of the balance of power between counties and cities and the state. And by statute, cities and counties have certain self-governance, including being able to get rid of nuisances. You can tear down houses that are left alone and all. So City of Weirton passed an ordinance that limited where you could locate oil and gas drilling stuff. And they had specific distances from streets and other things. And so they really limited and within the city what you could do. And so this case was a challenge to whether they could do that. It goes to the Intermediate Court of Appeals, and in a 3-0 decision, Judge Scarr writes that the state law preempted the City of Weirton's right to do that. Now, while the City of Weirton has certain statutory rights, they're secondary to state law, which placed in a state agency the governance of oil and gas permitting and location and all that. And so, you read the opinion, it's very, very detailed, going through the statutes that empowered the state agency to control this. and concluding that you can't, and I think the takeaway is, to the extent that there is a state statute that places, like in the DEP or another agency, certain powers, you can't have 55 counties doing different things in however many cities. So really kind of an important case about state law preemption. I'm not sure if this is going up to the Supreme Court or if it went back down, but I think this issue at some point will get to the Supreme Court. But there is a lot of environmental and other litigation going on with counties and that pass ordinances and things, and so if it doesn't go up in this case, we're going to see this issue again. But this stands for the proposition that statutory powers granted to state agencies are going to trump counties or cities.
Well, let's talk about a couple of commercial cases. Across the country, you're seeing a lot more business-to-business disputes, contract-based litigation, and these cases reflect that sort of trend. CIT is a case that kind of just got out of control, ended up in a huge verdict in Hampshire County. It involved a foreclosure that the bank was actually trying to rescind, and they ended up getting sued in a counterclaim. The bank's lawyer in the middle of the case, his firm cratered. He's a Virginia lawyer with a West Virginia license. That firm cratered, and as a result, he just dropped the case and stopped working on it, including missing hearings and that sort of thing. Better West Virginia counsel showed up and picked up the case and took it to trial. The result was a $2 million verdict because while a foreclosure action is essentially a contract case, there were all these tort claims that were asserted, and a lot of them were duplicative. On appeal, the Intermediate Court said the gist of the action doctrine, which says that if the basis of your claim is a contract claim, then you cannot have duplicative tort claims for the same injury resulting from that. And as a result, the vast majority of this $2 million verdict was vacated. Because of the misconduct of the lawyer who just stopped working on the case, the judge awarded attorney's fees, even though it's not a fee-shifting case. I think it was like $600,000 worth of fees. And because the court had given the plaintiffs a third of the verdict as an attorney's fee on top of the verdict, which took the total verdict to like $2.5 million. Because punitive damages had been stricken because the Court of Appeals said there's no basis for punitives because you also had a claim that trumps your ability to assert punitives, outrageous conduct claim. They've sent it back for that. This case was appealed last week to the Supreme Court of Appeals. We'll see where it goes from here, but it's a much smaller, they didn't reverse all of the claims, but it's a much smaller case than it was going in. PETA versus Siegel is simply a case that stands for, in a very complicated set of facts, that if you are the guarantor on a note, that your attempts at collaterally attacking your obligations are unsuccessful. That is essentially, in the course of a 50-page opinion, that's what that boils down to. And then BlackRock was a case that looked at the first material breach issue, where if you have a business-to-business dispute and both sides are claiming that one side breached, normally the most material breach carries the weight, but this court did a very good description by Justice Wooten of explaining the first material breach, how that plays out. So this is a good example of getting the sort of explanation regarding questions in business-to-business disputes that we had not really addressed in previous cases.
Next are two cases from the Intermediate Court of Appeals that deal with the public access to governmental documents and governmental decision-making that are worth a brief mention anyway. So the first case, Gray Media Group versus DHHR, arose following the department's termination of their deputy secretary that caused quite the news story when it happened. And the newspaper, WSAZ, filed a FOIA claim against a FOIA claim against the DHHR saying, hey, we want to see the termination letter that you guys provided to the deputy secretary. The circuit court below had said, no, I think that's subject to the invasion of privacy exemption of FOIA, and the WSAZ took it up to the Intermediate Court of Appeals, who said, This really involves the operation of government and the performance of a high-ranking official's public duties. There's very little personal privacy, expectation here, and for the same reasons, there's a very heavy public policy of, the public being able to see their public officials discharge their official duties. So they ordered that the termination letter be disclosed to WSAZ. The next case is HD Media v. WVU Board of Governors, and this involves a claimed violation of the West Virginia Open Governmental Proceedings Act. And the newspaper here, the Charleston Gazette-Mail, had alleged that the Board of Governors violated the act by going into executive session to discuss 9 topics during various meetings over the summer of 2020. And the topics ranged from WVU's budget issues to addressing social justice on campus, Title IX regulations, and even the athletic director's talk on the prospects of the upcoming football season.
Which ought to be secret.
Sure. Beat Penn State. So the newspaper, circuit court granted summary judgment in favor of WVU, and the newspaper appealed. And the court first noted that it's the governing body's burden to bear to show that these exceptions actually apply. And then it went and addressed the commercial competition exception, which allows a governing body to go into executive session to consider matters involving or affecting the purchase, sale, or lease of property, advanced construction planning, the investment of public funds, or, and here's the kicker, other matters involving commercial competition. And so the majority opinion in this case said, hey, this other matters involving commercial competition, WVU supplied a bunch of affidavits that supported their interpretation of this, and that, hey, this stuff all kind of affects, whether students come here, whether they spend dollars here. It's all part of that matters involving commercial competition. The court, throughout the opinion, noted that the newspaper didn't really engage in any discovery and didn't find any evidence to support its case. So although the newspaper bared the burden, it was certain most of the evidence was undisputed. And so they say it fits within that exception. But at the same time, the court was cautioned lower courts not to read too much into this opinion. And you see trails of this throughout saying, hey, this was kind of, the summer of 2020. This was kind of the height of the pandemic. We're going to cut them some slack here. Don't cite this, and be wary of other governing bodies who may try to overclassify things in this category. So we're probably going to see that issue come up again, given the expansive interpretation by the majority, which Judge Scar dissented and said, "Hey, I agree with everything they said, except for this their reading of this commercial competition exception, which seems to swallow the rule and really is at odds with the purpose of the Open Governmental Proceedings Act."
I think this is a really fascinating case. It could be the legal geek in me, but Tom Herney, also probably a legal geek, agrees that this is a pretty significant case in West Virginia. It's a workers' comp case. Mr. Rubel worked in a chemical company. He had some significant health issues. He claims that he believed that those were work-related due to chemical exposure. He filed a workers' comp claim, but he also filed a civil action against his employer and a string of employers who were owners and chemical suppliers, alleging that this chemical exposure had led to his injuries. The workers' comp case proceeded, and it was determined that they didn't believe that there was evidence of occupational disease by a preponderance of the evidence based upon the information that came forward. So his workers' comp claim was determined to not be compensable. So then there was an agreement that the employer would be dropped from the civil litigation, right, because there was a judgment, in which case one of the other chemical supplier defendants said, well, wait a minute, why do they get out of the case, but we should get out of the case too. And then they filed a motion to dismiss, claiming this claim's already been decided in the workers' comp realm. It's been decided that there was an exposure that caused an occupational injury here, and we're done here, right, because we've already got a decision. So the Supreme Court looks at this issue of whether there is collateral estoppel, right? Has the claim already been decided? Has the issue already been decided? Because claimants don't get two bites of the apple here, right? One of the elements in looking at a collateral estoppel argument is whether the claimant, the first time around, got to fully and fairly litigate the claims. The court here said, no, it's such a different process in the workers' comp realm that it is in a civil action. We don't think it's the same, and therefore we don't believe that there's preclusion to bring the claim here in the civil action. And things that they looked at included the fact that the rules of evidence don't have to be followed in a workers' comp setting, hearing that it's a much more informal process. The discovery is truncated, it's much more simple. The standard of proof can be different. There really isn't discovery about third parties like these chemical suppliers in this case. And so they said, no, this claim gets to go forward. Definitely an interesting case, and claimant got to go forward, even though his workers' comp claim was denied because it was determined there wasn't chemical exposure. Another interesting workers' comp case that came out of the last term was this Duff case. Duff was a police officer. He had a back injury. He had a workers' comp claim that was deemed to be compensable. The issue was whether or not he had a pre-existing condition that contributed to the injury, and so how much disability he should get in terms of a partial disability award for the claim. A doctor looked at it, said, I think you've got a 25% impairment, but you've got a pre-existing lower back injury here, right, which exists, and therefore I think we split it up, right, and you get 13% of it was for the pre-existing condition. We'll put 12% on this. There were competing doctors back and forth here. Supreme Court here says, look, the burden is on the employer here to establish that there was impairment, not just a pre-existing condition, because you can have a pre-existing condition that doesn't lead to impairment, and that's what the officer argued here. Yeah, I've had low back pain, but I didn't have numbness in my legs and tingling and all these other issues that I have here. Court found that the employer's doctor candidly didn't do a good enough job of explaining why he apportioned part of the fault to the pre-existing condition. And so it's really going to be important that in the workers' comp context, where there is a pre-existing injury of any type, that you've got a good and strong analysis from a doctor, because the employer is going to have to be able to show what that is.
Let's talk about a couple of insurance cases. For the most part, because a lot of chamber members have insurance disputes with their carriers, and there are a lot of carriers that are chamber members, there isn't anything that I would say in most insurance cases that would clearly reflect the perspective of the business community, except that compared to what we used to see in old courts 20 years ago or more, we would like to see a fair interpretation of the policy, a fair reading of exclusions. After all, an insurance policy is a contract that provides you with a certain amount of protection as a result of your payment of a premium for a limited amount of time. And a lot of these insurance policies have exclusions in them. And there's been a ton of litigation over the years about the extent to which exclusions apply. Now, the first case actually dealt not with exclusions, but with the whole issue of which insurance policy applies. And these are occurrence policies that covered a business that was sued as a result of chemical exposure. And the chemical exposure occurred over time. So the question is, there are multiple insurance policies that during that time frame, the exposure occurred over time and then it manifested itself with an injury later. Which insurance policy applies? And our court adopted the continuous trigger theory, which says all of the occurrence policies that would have been in effect during any of the exposures are applicable. Not claims made. Claims made are different. But for occurrence policies, all of them would apply. Scafella and Dobbins both deal with the way that certain policy language is interpreted. If you have a homeowner's policy, there's an exclusion in your homeowner's policy that says that you cannot operate a business there, or that any risk associated with the business operation at your home is not covered. You have to get a separate policy for that. And in this case, there was a claim under a homeowner's policy even though there was a business operation going on, taking place there. And the court said, no, that policy exclusion should be enforced. The Dobbins case is interesting because there is a provision under our uninsured motorist provision by statute which says if you have been injured by an uninsured motorist or by a hit-and-run driver, or you come out and see that someone's caved in the side of your car, you have to report it within 24 hours to law enforcement so that an investigation can take place. And unfortunately, this happens sometimes where a claim is made or a case is filed, there was no claim made within that 24 hours. In fact, in the Dobbins case, they didn't notify their carrier until 4 days later. The insurance company denied the claim. Litigation ensued. The court in Logan County actually said, well, 24 hours is what the law requires, but 4 days is probably close enough, and there's really no prejudice. The intermediate court reversed unanimously and said there's no prejudice basis for even having that analysis. The language is clear in the statute, and we're going to give it the enforcement that it requires. So under those circumstances, I think these insurance cases reflect what we want from our courts of appeals in interpreting insurance contracts.
Next, we have a statute of limitations case relating to products liability claims with coal respirators. And in this case involved 7 different plaintiffs that were consolidated for discovery and summary judgment. And the circuit court had dismissed the claims at summary judgment saying, hey, the statute of limitations bars these claims from being brought, and the plaintiffs appealed. Now, this was an intermediate court of appeals case, and they held that you're right, the statute has run. The statute begins to run. The 2-year statute of limitations applicable to these claims begins to run whenever they were awarded their work-related disability, were awarded disability for their work-related dust inhalation injuries, or when they were diagnosed with any sort of lung impairment from coal dust inhalation, or when they applied for black lung benefits. The court noted that there was no dispute that the plaintiffs knew which exact respirators they had used during their careers, and that they knew the respiratory health effects that were associated with coal mining, and they just sadly didn't bring their claims in time. And this case is on appeal, but to the Supreme Court. But it's the second case in as many years where the courts have upheld and applied the statute of limitations defense to bar claims, which seems to be a trend here. Although we'll see what the Supremes do with it.
We always throw in a few of the medical liability cases. The chamber was always heavily involved in the tort reform legislation starting in '86, again in 2001, 2003, 2015. It's consistent with the chamber's approach to civil justice reform. So just a couple quick things. You know, in West Virginia we now have several liability. So if you go in front of a jury and there's a $100,000 verdict and you get 10%, you pay $10,000. And there's no contribution back and forth. And it used to be, if there was a $100,000 verdict against 3 of you, the person with the most money paid it, and then they had to chase the other people. So the MPLA has similar provisions. Wingate versus Chawla is really interesting because the plaintiff sued 2 doctors for identical reasons. He thought the one doctor had gone back to his home country, so he just plaintiff voluntarily dismissed the doctor. Ultimately, case got up to trial. Defense, I represented the defendant, took the position that the absent doctor goes on the verdict form. And that's important because if there's a verdict, your client pays only their share. Judge Bloom at the time certified the question to the Supreme Court. Supreme Court said that because the dismissed doctor was a party as defined under the statute, his fault would be considered by the jury. So significant thing. Armstead's dissent is really interesting in the case, or his concurring opinion, because he says they should have also applied the more general statute that I just discussed, and that the same analysis would apply. So this stands for the proposition that if you dismiss a defendant, they may go on the verdict form. A lot of other issues that go with who goes on the verdict form, but with several liability, it's really important and really tough on the plaintiff's side, by the way. Sager versus Duvert is, we've talked about notice of claim and certificate of merit. If you don't follow the statute and send those pre-suit papers, as the statute requires, circuit courts have no subject matter jurisdiction. What this case says is there's a part of the statute that says you can go to the defendant and say, I don't have enough time to get a certificate. And you automatically get 60 days. What this case says is once that 60 days expires, you're done. You've got to follow the language of the statute and the time frames in the statute. If you then file suit, it's dismissible for violation of the 55-7B6. Trivet is a really tangled case, but at the end of the day, it stands for the proposition that in determining to whom the Medical Professional Liability Act applies, they're going to look at whether you are a healthcare provider, a healthcare facility. In that case, it was the County Office of Emergency Management. It was the 9/11 operator. And they argued, well, the 9/11 operator is like any other healthcare because they're getting a message that someone needs healthcare and they're arranging for it. And the court said that doesn't really come within the statute, and the Wooten majority opinion said no amount of linguistic acrobatics can turn these respondents into healthcare providers. And so just three cases that show, to me, the court's going to read the statute and apply it, and it's not always going to end up as a win for the defendant, and as demonstrated by the last case. So let's talk about what's on the horizon, and my friends will chime in. We talked about the opioid cases. We've got two opioid cases headed to the Supreme Court. One that relates to the mass litigations panel dismissal of cases brought for babies born with addiction. And that was a pretty long dismissal order. It's on appeal. The other one is the Supreme Court will consider the City of Huntington case where City of Huntington sued opioid distributors, went to trial on a theory that opioids are a nuisance. Ultimately, Judge Faber determined that West Virginia law didn't recognize that. So we're going to see that. Ford v. Tyler, which I talked about, is likely, I think it's fully briefed going up to the Supreme Court. The St. Joe's Hospital case is notable for, it's a kind of garden variety healthcare authority case. It's notable because the appellant is challenging whether the state should continue to follow the Chevron doctrine. And many of you will know the Chevron doctrine is where that a court will defer to an agency's interpretation of a statute. The United States Supreme Court did away with the Chevron doctrine this past term, and so there will be an issue as to whether the state Supreme Court will eliminate the state version of Chevron. Orphanos is an MPLA case. It's the first case on the trauma cap, which did an overall limitation on damages of $1.5 million if a defendant is found liable. There's a whole bunch of other issues, but that'll be a case of first impression. So we got 2 or 3 cases that are probably first impression that we will likely be talking about next year. If I miss anything?
Nope.
You sure?
It's cocktail hour.
Yeah. We're holding you too late.
So I'm going to skip the questions, and I'm going to go right. Thank you to our wonderful presenters and to our sponsor, Progressive. And as a last reminder, if you have not signed up for CLE credit and you're a West Virginia attorney, please sign up at the table to the left of registration in the Cameo Ballroom. It will be open tomorrow. We want you to get that credit, so please sign up, and everyone enjoy your evenings. Thank you.
Nice job.
Thanks. Seems to go well. Well enough.
Good job. Yeah, that's a good way to use it.
Sure.